I'm Ben Meiselas from the MeidasTouch Network. Donald Trump's former chief of staff and current co-defendant Mark Meadows in the sprawling Rico criminal case brought by Fulton County District Attorney Fani Willis has filed yet another aggressive filing in federal court. A motion to dismiss late on Saturday was brought by Mark Meadows' counsel, seeking to dismiss the indictment in federal court, where Mark Meadows just removed the matter to on the grounds of Article 6, Section 2 of the United States Constitution, the Supremacy Clause, and/or in the alternative, seeking to dismiss the indictment on the First Amendment and 14th Amendment, respectively. Mark Meadows last Tuesday on August 15th, following the indictment voted on by a Fulton County grand jury, where 18 additional co-defendants, in addition to Donald Trump, were criminally charged. Meadows filed a removal notice on Tuesday to remove the case from Fulton County Superior Court, where it was pending before a new judge, Judge McAfee, to a federal judge, Judge Steve Jones, in the Northern District of Georgia. We reported on the removal notice last week. The way it works is when a party removes to federal court, asserting some sort of federal jurisdiction, the court can take briefing, have an evidentiary hearing on the matter. If there's no federal hook or federal jurisdiction at all, the federal judge can just do what's called a remand, or immediately send the case back to state court. That's what the remand is. And if the federal judge doesn't rule, the party who brought the lawsuit, in this case, in the criminal case brought by Fulton County District Attorney Fani Willis, she would seek what's called a remand motion. Last week, though, Judge Steve Jones, the federal judge from the Northern District of Georgia, who was assigned the removal by Mark Meadows, ordered that there be an evidentiary hearing to be held on August 28th. That date may sound familiar to you because that is also the same date where in federal court in Washington, D.C., Judge Tanya S. Chutkin, presiding over the case brought by Special Counsel Jack Smith against Donald Trump, where Trump was indicted in Washington, D.C. A trial-setting conference is scheduled there on August 28th as well. And so there is this procedural quirk right now, because the judge, the federal judge, Judge Jones, has not yet ruled on the potential remand back to state court and whether there's jurisdiction. But Mark Meadows is moving full steam ahead regardless, and then filed this motion to dismiss, as I mentioned at the outset of this video, citing the Supremacy Clause, Article 6, Section 2, as well as the First Amendment and the 14th Amendment. Let's just kind of break this down in general. The first hurdle for Meadows is going to have to show the case belongs in federal court. And so to do that, it's a three-part test. First, was he a federal official? Second, was he acting under color of law? Three, does he have credible federal defenses? I think he is a federal official. I think that he's not acting under color of law. Meadows will argue he was just doing his job as required as a chief of staff, just setting up meetings and moving things along. Fulton County District Attorney Fani Willis is going to say, no, you're trying to overthrow democracy. It's part of a criminal Rico enterprise to destroy our Constitution. So not under color of law and no credible federal defenses. But question one is, can he be in federal court? And then you would get to the motion to dismiss. And Meadows cites the Supremacy Clause, which is kind of similar to the argument of why he thinks he should be in federal court. He's basically saying that a state court should not have jurisdiction over his duties as a chief of staff in the federal office that he held. And a state prosecutor should not be able to prosecute him for doing tasks consistent with what a chief of staff does. That's his Supremacy Clause argument, which is similar to his 14th Amendment argument. And his First Amendment, he claims he was just acting in furtherance of his free speech rights and just pursuing his job. Of course, Fulton County District Attorney Fani Willis will argue, no, you were trying to overthrow our government. You were trying to overthrow a free and fair election. You can't invoke the supremacy clause of the Constitution where you go into a state and then try to overthrow a free and fair election in the state of Georgia and doing that nationally. So, that's going to be the arguments that are made. Ultimately, for Mark Meadows, one of his key reasons why he wants this to be litigated quickly in federal court is his plan. The 11th Circuit Court of Appeals is a very right-wing court with lots of Trump appointees and George W. Bush appointees. And Meadows' calculation is, and this is why they're filing all of these motions so quickly, is even if he loses the motion to dismiss before Judge Jones, the federal judge in the Northern District of Georgia, he'll take an immediate appeal to the 11th Circuit, and he's going to hope the 11th Circuit, Trump judges, George W. Bush judges, would bail him out. That's ultimately his plan right there. Let's take a look at his motion, though, just so you can see the arguments that he is making. And I think you can see why I believe his arguments are without merit, but let's take a look at what he actually writes. Defendant Mark Meadows moves to dismiss the indictment against him pursuant to Rule 12b-1. That's a motion to dismiss. That's the rule of federal rule of civil procedures. It goes on to say, as a federal official at the time of the charged conduct, he is immune from state prosecution under the Supremacy Clause of the Federal Constitution, United States Constitution, Article 6, Clause 2, and then it cites an 11th Circuit case, because that's the play here, is really to the 11th Circuit. The state's prosecution of Mr. Meadows threatens the important federal interest in providing the President of the United States with close confidential advice and assistance, firmly entrenched in federal law for nearly 100 years. And then he cites Elena Kagan, the Supreme Court Justice appointed by Obama, in her brief, because again, his audience is 11th Circuit and Supreme Court, and gives rise to precisely the sort of state interference in federal affairs the Supremacy Clause prohibits. Centuries of federal precedent make clear that states may not impede or interfere with the actions of federal executive officials when they are carrying out federal laws, and that a federal official carrying out his duties is not obliged to consider state criminal law at all before acting. Federal courts enforce these fundamental constitutional principles by granting immunity in the state prosecutions and dismissing charges under Rule 12b. Then it goes, Mr. Meadows removed this proceeding from the Superior Court of Fulton County, Georgia, under the Federal Officer Removal Statute, 28 U.S.C. Section 1442, on Tuesday, August 15, 2023, the day after he was indicted on 2 state law counts as part of a 19-defendant, 41-count case under Georgia's Rico law. This court declined summary remand on Wednesday, August 16th, and set an evidentiary hearing for Monday, August 28th, 2023, after which the court will make such disposition of the prosecution as justice shall require. And then it goes on to cite additional law there. But as you go through, how this motion to dismiss is structured, argument 1 is that Meadows argues he's immune from state's prosecution under the Supremacy Clause. And then sub A, he goes, the charged conduct carried out while Mr. Meadows served as Chief of Staff to the President of the United States has a nexus with furthering federal policy. Then it talks and it tries to characterize his work that he was doing and that he's being charged for as just, hey, this is routine work that chief of staffs do, and this was furtherance of official federal duties. And then he goes on to say, well, even if there isn't a Supremacy Clause argument under the First Amendment and 14th Amendments, he believes the case should be dismissed at all. Worth noting, again, very aggressive moves made by Meadows. Meadows filed the removal notice the day after the indictment, and within less than a week of the indictment that was brought on Monday, he's filing this motion to dismiss, citing the supremacy clause. So really kind of what happens next? Well, what I believe happens next is I think you're gonna have to have the hearing first on August 28th on whether there's even federal jurisdiction in the first place, or whether the case is going to get sent back to state court. It is possible that the judge addresses all of these issues together, but now Fulton County District Attorney Fani Willis is going to file an opposition to this. It'll go on a briefing schedule. And Fani Willis is going to argue, what in the world are you talking about? You don't get a free pass to commit crimes in the state of Georgia. You weren't acting in the capacity as a chief of staff furthering the interests of a president. You were furthering the interests of a criminal enterprise, is what she'll argue. Then it'll go to Judge Jones. Depending on the ruling, I think either way, could go to the 11th Circuit Court of Appeals, ultimately to the United States Supreme Court. But the removal issue only applies to federal officers. So, arguably the only people who could claim that status are Meadows, Trump, former federal officers, and Jeff Clark, the disgraced Department of Justice official who tried to overthrow the election, who's also a co-defendant. All of those would go before Judge Jones as well. But lots of briefing, lots of legal maneuvering taking place right now, and some very aggressive moves there by Mark Meadows. I'm Ben Meiselas from the MeidasTouch Network. Go to MeidasTouch.com. We have Meadows' motion there. We also have some analysis there as well. And you can check out all the other breaking news at MeidasTouch.com as well. Have a great day, and make sure you subscribe to our YouTube channel. It is free.
At MeidasTouch, we are unapologetically pro-democracy, and we demand justice and accountability. That's why we're spreading our message to Convict 45. That's right, gear up right now with your Convict 45 tees and pins at store.MeidasTouch.com. That's store.MeidasTouch.com.